Hello, I am Giovanni Guglielmo Crudeli from University of Naples Federico II, and I'm going to present you the poster about the use of autonomous artificial intelligence systems and employer liability. About this matter, particular attention should be paid to the use of two self-learning artificial intelligence systems and the repercussions of safety profiles in the workplace that their use determines. In fact, unlike traditional mechanical technological instruments, whose operation is characterized by seriality of operation and absolute controllability of the activity, robotic systems equipped with strong AI are characterized by decision-making autonomy so that their operation may turn out to be unexpected and far from the expectation. The relevance of the issues raised has received attention both by doctrine and by legislators, particularly European ones, as can be seen in the AI Act. In the recently approved regulation, it's expressly stated that it is inspired by the need to regulate the use of AI by guaranteeing the protection of the health and safety of individuals, also including workers. In this direction, the regulation adopted by European legislators is focused on risk management by those who produce, market, and use AI systems. The regulation, taking into consideration the level of impact that the artificial intelligence system can have on the individuals who interact with them, identifies different levels of risk. In relation to the individual degree of risk, the regulation provides for stringent obligations to be met by the various subjects identified in order to lawfully market such systems or to be able to use them. The issue is that the regulation does not provide about liability profiles for damages arising from the use of technologies equipped with AI. In order to build a comprehensive system of liability for the use of systems with AI, the European Commission has started the process of issuing two different directives: the Directive on Liability for Defective Products and the Directive on Artificial Intelligence Liability. The first of two proposals concerns the revision of the Directive on Defective Products in order to make it compatible with the aspects relating to the marketing and use of innovating technologically advanced products, such as robots. The second proposal represents an actual new directive on liability for artificial intelligence and facilitating compensation from not contractual liability in favor of those who suffer damage resulting from the use of AI system. In the absence of the adoption of a specific regulation on the subject of liability arising from the use of AI systems, there is a need to bring the case under examination back to the schemes of liability for damage, making reference to the traditional rules on civil liability. In this perspective, it is inevitable to question the compatibility and the possible sufficiency of the provisions contained in the Article 2087 of the Civil Code. In this regard, the Article 2087 of the Civil Code represents a case of contractual liability for fault, calmed by the possibility for the employer to prove that he has employed all the measures that can be adopted in relation to the peculiarity of the work experience and technique. Limits that put in relation to the particularities, complexity, and the opacity of evolved AI systems could widen the space for the exclusion of the user subject's liability and therefore represent an impediment to the recognition and adequate protection for workers damaged by robotic means that the employer inserts in his company. In this sense, among the liability hypotheses provided for the Civil Code in force could be demanded after the recourse to the Article 2049 of the Civil Code, regulating the liability of masters and principals for damage caused by the wrongful act attributed to their servants and committed in the exercise of the duties to which they are assigned. Thank you for attention.